Thank you very much. Good afternoon to all the distinguished guests here. Instead of any formal letters to a galaxy of personalities whom I know personally and with whom I am associated for a long time, with your kind permission, may I just start with the subject of today's interaction with you. I propose to speak on the 2018 Amendment Act in the specific relief act with reference to, because I was asked to that, keeping in view the economic dimensions and the India marching ahead as a very strong economy in the global map, what are the consequences, what are the effects and impact of the 2018 amendment in the specific relief act? I just thought that I will share my ideas on that. The 2018 amendment to the specific relief act and its potential implications for India's future, both domestically and internationally, is the subject of discussion. India's evolving global positioning becomes particularly pertinent in this background as it closely aligns with the modifications introduced by the amendment and the overarching object it aims to fulfill. When we speak of disputes arising from the breach of contracts with reference to the original Specific Relief Act of 1963, the granting of remedies to aggrieved parties is rooted in the old principle of ubi ius ibi remedium, which means that where there is a right, there is a remedy. The remedy of specific relief is treated differently across jurisdictions. For instance, civil law jurisdictions most commonly treat specific relief on the same level as a remedy for compensation of damages, whereas this is not so in common law countries. India, being a common law country, has treated the remedy of specific relief for several decades as one steeped in the principle of equity, but paradoxically subject to judicial discretion. In this regard, the legal framework governing the remedy of specific relief in India was encapsulated in the Specific Relief Act of 1963. The objective of this particular statute is to essentially safeguard civil rights and provide remedies for people whose contractual rights have been infringed. The remedies traceable under the Act include a recovery of possession of property, rectification of instruments, specific performance of contracts, rescission, and injunctions, among several others. However, despite its wide import, this legislation was often perceived as rigid, primarily due to the imposition of the inadequacy test, which in turn is founded upon the notion of reversed onus of proof. Under this test, an aggrieved party seeking the remedy of specific performance was required to demonstrate that damages under the common law was either unascertainable or an inadequate relief. This test applied to suits for specific performance of contracts as well as to injunctions sought for enforcing contractual obligations. Consequently, specific performance was treated as an exceptional remedy, granting only when court was satisfied that the alternative recourses were wholly deficient and its decree would be effectively enforced. When Section 10 of the 1963 Act codified the inadequacy test, Section 14 and 20 of that Act enumerated exceptions to the grant of specific performance, such as the availability of monetary compensation or the impracticality of enforcing contracts involving minute details, with courts predominantly favoring the award of damages in cases of breach and specific performance being invoked only as an exceptional remedy. The efficacy of the 1963 Act was significantly undermined. the lack of mandate for specific performance of a contract, irrespective of mitigating circumstances exhibited by the losing party, substantially affected the sanctity of contractual obligations. I believe that it is not uncommon for parties to breach their contractual obligations as the damages awarded often prove to be less burdensome than the cost of performance. Promisors frequently resort to breach when the gains from such breach outweigh the damages assessed by the court. This phenomenon aligns with the efficient breach theory in law and economics, which posits that voluntary breach of contract accompanied by the payment of damages can be economically justified. Proponents of this theory contend that in certain instances it is economically efficient for contracts to be breached. By limiting remedies to monetary damages, the legal framework arguably incentivizes parties to breach contracts when the cost of performance exceeds its perceived value. This, to my mind, eventually derailed the aim of the statute to provide relief to parties and functioned almost as a sort of ancillary legislation with not much application. Now, in this legal framework of the 1963 Act, then came a 2016 expert committee's recommendations. That being the state of affairs, over time it became evident that the existing framework under the Specific Relief Act 1963 was increasingly unfeasible, and an expert committee was therefore constituted to undertake its review. This decision was necessitated by the substantial developments that had occurred since the 1963 when the Act was enacted, particularly in the context of contemporary scenarios involving contract-based infrastructure development, public-private partnerships, and other public projects requiring abundant investments and enforceability of contracts. The review was also aimed at aligning the Act with the objective of ensuring the ease of doing business. Notably, the Specific Relief Act had not undergone any amendment since its inception. The expert committee, therefore, in its report, underscored that the Specific Relief Act in its existing form was inadequate to address the demands of India's rapid economic growth and industrial expansion. It emphasized the need for extensive reforms to facilitate the enforcement of contracts and ensure timely dispute resolution, both of which are crucial to the creation of a business-friendly environment. More specifically, the committee highlighted the limitations of the inadequacy test, which restricted the remedy of specific performance to a narrow set of circumstances. It observed that in many cases, plaintiffs were unable to fully substantiate the losses incurred due to a breach, nor were the claimed amounts consistently awarded. While damages might compensate the injured party, they fall short of fulfilling the contractual obligation that the remedy of specific performance is designed to achieve, often resulting in delays and additional costs. If I were to express this analogy in my own words, denying specific performance in favor of awarding damages is something like refusing indoor admission to a patient, to a critically rather ill patient, and opting instead to administer him just the basic first aid. While the latter may provide some relief, it often falls short of addressing the underlying issue comprehensively, leaving the affected party inadequately remedied. Let us also see when the 2016 committee was constituted and it's decided to make certain sweeping recommendations for amendment in the 1963 Act. Let us see what were the position in law in various other jurisdictions. When we peek over the fence and look beyond our own legal system, the remedy of specific performance varies significantly across jurisdictions, reflecting the diverse approaches to contract enforcement. Under common law systems, specific performance is directed against the defendant personally, where the court requires the defendant to fulfill their contractual obligations or face the consequences, such as being held in contempt. In contrast, civil law systems take a broader view. The remedy focuses on achieving the promised result for the promisee rather than merely directing the debtor to act. This approach allows the promisee to have defects cured or substitutes obtained at the promiser's expense. In common law nations, and that I will refer to in United States of America, specific performance may be ordered if explicitly provided for within the agreement. However, the limitations remain the same, namely, specific performance is generally resorted to only when legal monetary damages are inadequate or an incomplete remedy for breach. Similar is the situation in the United Kingdom, where broad discretionary powers are granted to the courts. Even in civil law jurisdictions, though the applicability of specific performance is propagated, nonetheless, actual performance of a contract is ordered only in exceptional cases. In countries like France and Germany, the laws are quite wide and they allow substituted performance instead of actual performance, subject to the imposition of restrictions. For example, German law grants specific performance as a matter of right, but with limitations tied to the adequacy of compensation. Enforced performance is typically ordered only when monetary compensation is inadequate. This includes situations where a profit-earning asset is damaged and the loss of profits during the repair period cannot be adequately compensated. However, under the German law, if specific performance results, it's quite interesting provision. If specific performance results in the promisee receiving a benefit greater than what was originally agreed upon, specific performance can be denied. Instead, the promisee would be entitled to compensation equivalent to the value agreed upon by the parties at the time of entering into the contract. A common limitation across most of the jurisdictions pertains to personal contracts, particularly those requiring the promiser's personal services. Courts generally, and in my opinion rightly so, refrain from enforcing such promises in light of potential infringement and violation of personal freedom and liberty. Additionally, courts are often reluctant to oversee or evaluate the quality of personal service, which could involve significant judicial supervision. Lastly, all legal systems recognize the impossibility of enforcing specific performance where it is not feasible for the promiser or any third party to fulfill the promise. This principle underscores the practical limitations of the remedy across jurisdictions. Now, reverting back to the recommendations of the 2016 expert committee and the deficiencies pointed out in the Specific Relief Act of 1963, along with the transformation of the economic landscape, the 2018 amendment, to which I am now straight coming, the 2018 amendment came into force. This amendment indeed marked a significant shift, making specific performance available as a matter of right rather than an exception. This amendment is a testament to the measure that India has effectuated in comparison to other contemporary jurisdictions to create a more streamlined framework which fosters predictability and certainty in commercial contracts. One of the most crucial changes brought about by the 2018 amendment, in my considered opinion, it relates to the onus on the plaintiff to prove readiness and willingness to perform their contractual obligations. Under the old framework, the plaintiff was required to make an express averment to this effect in their pleadings. The amendment thought it retains the burden on the plaintiff to prove readiness and willingness, but it does away having to specifically make any averment to this end in the pleadings. Similarly, the amendment removes the prohibition on enforcing contracts with arbitration clauses through specific performance, allowing for a more integrated and pragmatic approach to dispute resolution. In contrast to the earlier provision, which allowed compensation either as an alternative or in substitution of specific performance, the amendment enables plaintiffs to claim compensation as an additional relief alongside specific performance. This ensures that plaintiffs are adequately compensated for losses while also obtaining the performance of the contractual obligations. Moreover, the courts are now empowered to appoint experts. This is also a very significant provision that has been added. The courts are now empowered to appoint experts to examine the nature of commercial contracts, determine breaches, and assist in resolving complex issues. These experts may also be examined by the parties subject to the court's permission, which introduce a more informed and effective adjudication process. The 2018 amendment also brings to fore the concept of substituted performance, allowing an aggrieved party to procure the performance of the contract from a third party or its own agency in the event of a breach. The expenses incurred for such substituted performance can be recovered from the defaulting party. Additionally, the amendment includes provisions to allow third parties who have been conferred benefits under a contract to specifically enforce such agreements. This serves as an exception to the traditional doctrine of privity of contract, expanding the scope of enforcement in line with contemporary needs. Recognizing the complexity and public interest involved in large-scale infrastructural projects, particularly those involving government agencies and public-private partnerships, the amendment of 2018 places an embargo on granting injunction that could delay or impede the completion of the infrastructure-based projects. To further streamline this, the 2018 amendment provides an exhaustive list of infrastructure projects covered under the statute, ensuring clarity and uniformity. Special courts are also to be designated by state governments to handle suits related to infrastructure contracts under this Act, enhancing efficiency in resolving disputes in such critical areas. Lastly, to address delays in litigation, the amendment mandates the expeditious disposal of all matters under the Act within 12 months from the date of service of summons to the defendants, within a maximum extension of 6 months. This time-bound resolution conforms with the overarching objective of facilitating an enterprise-friendly landscape and ensuring swift enforcement of contractual obligations. The Act, of course, ideally provides for adjudication of these suits within 12 months. But I have a caveat here. When a law is enacted fixing timelines for expeditious disposal of cases in a timeline manner, it is equally critical to conduct corresponding judicial impact assessments while also making adequate provisions for enhancing judicial infrastructure to meet such challenges. I hope this aspect the stakeholders will keep in mind. These changes through the 2018 amendment that I have highlighted are only a few instances among the many that seek to collectively modernize the Specific Relief Act, aligning it with India's evolving economic topography and emphasizing timely, efficient, and effective resolution of contractual disputes. Essentially, the amendment to the Specific Relief Act of '63 aimed to create a more pro-business climate and secure setting by making specific performance the rule rather than the exception, with damages serving as an alternative remedy. This shift reflects a stricter approach to enforcing promises performance, acting as a deterrent against uncertain and undesirable contractual behavior. Greater certainty in contract enforcement is expected to enhance India's attractiveness as a destination for both foreign and domestic investments, which would greatly contribute to the economic growth of the nation. The expanded availability of specific performance also offers notable efficient outputs, minimize the risk of undercompensation or the risk of overcompensation. It reduces the reliance on liquidated damages clauses. It also limits strategic behavior and mitigation challenges. And most importantly, it grants primacy to the moral obligation of honoring one's promise. This provision, I'm talking 2018 amendment, one of the clause, has also successfully mixed moral science into legal framework. What was earlier understood to be a mere moral obligation has now been made an enforceable obligation. Additionally, it simplifies the litigation process by avoiding the complexities associated with calculating damages. In essence, the amendment not only strengthens the enforceability of contracts, but also the broader objectives of promoting economic stability and encouraging greater certitude among investors, ensuring that contractual obligations are met efficiently and equitably. It represents a key advancement towards addressing the uncertainties surrounding the execution of contracts in India. India is presently positioning itself as a global economic powerhouse driven by comprehensive legal, policy, and judicial reforms aimed at boosting investors' confidence and trade-enabling infrastructure. However, this was not always the case. Post-independence, India largely adopted a closed economic model with limited trade and restricted access to its markets for foreign entities. This approach was driven by a focus on self-reliance and protection of the domestic industries. The transformative journey of India's economic conditions was initiated through the pioneering reforms of 1991, defined by a total overhaul aimed at restructuring the economy. The post-1991 era emerged as a definitive catalyst for foreign direct investment inflows, witnessing a remarkable surge propelled by regulatory reforms and the opening of India's economy to global investors. Transitioning from a modest annual growth rate of 23% during 1981 to 1990, FDI experienced a remarkable acceleration, soaring at an annual rate of 44%. I believe that India now asserts itself as an economic powerhouse, having secured FDI of US $725.96 billion over the last 10 years and foreign institutional investment of $38 billion across sectors such as service, software, telecommunications, pharmaceuticals, and automobiles. Despite instabilities occurring throughout the world and overcoming the slowdown brought by the COVID-19 pandemic, I am also informed that as per the World Bank's Ease of Doing Business report, India has improved its position from 142nd in 2014 to 63rd in 2019, reflecting significant strides in regulatory and procedural efficiency. Additionally, there seem to be heightened efforts toward reducing over 39,000 compliances and decriminalizing some old and obsolete laws. In fact, judicial efficiency, which is a key component of the Ease of Doing Business Index, has also received considerable attention. India's lengthy dispute resolution process, averaging 1,445 days to resolve a commercial dispute, as per the 2018 report, has substantially reduced. Establishing commercial courts at the High Court and District Courts levels in 2015 has also streamlined the resolution of the contractual disputes, reducing delays and costs. I believe that the judiciary has taken a pragmatic approach in interpreting commercial laws, instilling confidence among foreign investors, and fostering domestic business growth. The repeal of laws like Sikh Industrial Companies Act of 1985, to which I have at once prescribed as the sanctuary for defaulters, has also contributed to reshaping the legal framework. While it may be premature to place complete trust in the quasi-judicial commercial tribunals such as the National Company Law Appellate Tribunal or National Company Law Tribunals, their potential for success lies in appointing subject specialists under secure and transparent service conditions. A fair and independent working environment for these tribunals could mark a significant milestone in India's progress. Given this metamorphosis, the role played by the 2018 amendment to the 1963 Specific Performance Act becomes especially focal, as it is vital in enhancing enforceability. The crux of this amendment can be captured by the words of, I remember Sir Edward Fry, who in his epochal work on the specific performance of contract says, a perfect system of jurisprudence, I'm quoting him, a perfect system of jurisprudence ought to enforce the actual performance of contracts of every kind and class, except only when there are circumstances which render such enforcement unnecessary or inexpedient, and that it ought to be assumed that every contract is specifically enforceable until the contrary is shown. What finally becomes apparent is that the 2018 amendment is part of a larger strategy to ensure that India's legal landscape is copacetic with the needs of international businesses, prompting trust and ease of doing business program, while also improving its own global economic standing. However, it also highlights the ongoing need for further reforms to address existing gaps and complexities, particularly when viewed through the perspective of foreign investors. I firmly believe that the time is ripe for engaging collaborative exchanges among jurisdictions built on mutual understanding and respect for cross-border legal frameworks. By creating an ecosystem where the sanctity of commercial laws in such countries who believe in the rule of law and is mutually recognized, we can pave the way for more seamless international trade and investment. Such cooperation would not only strengthen global legal harmony, but also inspire greater trust and confidence in transnational commercial dealings. With that, I conclude my remarks and hope that I have been able to throw some light on the 2018 amendment, which let us see in due course of time how it really gives a path, a roadmap for I would say, a very fast economic growth which we expect for the country because of the impediments created by the litigations arising out of different kind of contracts. I hope that at least in commercial contracts, the things would now become easier as far as the enforcement part is concerned. Thank you very much for giving this opportunity to me to share my view. Thank you.